Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge Stevens in Texas. He has a couple before him who are defendants in a injury case to one of their little ones. And because of that, they have a no contact order. They would like contact. The only thing is CPS does not want contact at all. So in my mind, there's got to be more to this than just what this man says. So I'll let you guys watch.
I've got Taylor Spike. And Raymond Spike.
That's correct. He's present also.
Who's on the DA's on that one? Okay. I have two cases on this one. Just 1 second. I have two cases here, and this is all right if we do them collectively?
Yes, Your Honor.
Okay, in each of these cases, 22-39093, Kayla Spite, is it Spite? Spate. Was placed on 10 years deferred or unadjudicated probation for injury to a child. And then here, Raymond Spate in 39094 was also placed on a 10 years deferred or unadjudicated probation for injury to a child, the same victim.
Same case.
And let me, we've got thousands of these, and I can remember a lot of them. And this all was probation on the court assessed on September 14th of 2022, which is a little over a year and a half ago. And that was for 10 years. Okay. Go ahead. What are we doing?
Well, Judge, I filed a motion asking the court to modify the conditions, allowing both of the Spates to have access to their child.
Both
for
of the what?
visitation.
The
Have
defendant?
access to their child. Both defendants have access to their child. They have a no contact order. We've been here a few times, but the last time we were here, the state was represented by Ms. Duchamp at the time. And there was sort of a court, state, and defense agreement that in probation's agreement that they would need to complete a chaperone program before they could have some sort of visitation. And they have done that. And we are now back today with those completed.
Well, Mr. Duchamp's not
That's
here
correct.
anymore. Ms. Dobb is.
That's
And
correct.
I have great faith in the way she does things. She seems to be a very fair and very decent person.
I totally
So,
agree with that.
So I'm going to trust what input she has on this.
Your Honor, given that they did complete that class, the state does not have any objection to them having supervised visitation with their child.
We're going to wean this along one step at a time. What's the status of the child's physical condition? That's what I want to know.
The children are fine. They live with a
I'm talking about physically. How they doing? There was serious bodily injury here, just Stella Rose. So what's this? I'm interested to know what the status of the medical condition on Stella is. I don't know.
they don't have
They
access to
wouldn't,
their
they
child.
may not know.
Right.
Do we have, does the state know anything about
I
it?
have not talked to the new custodians of the children, so I don't know.
Well, yeah, I think that's important, isn't it? To know how the child is progressing and
She, from what we understood, the last thing that we knew, she's autistic.
Cerebral palsy and
Yeah.
because of this, right?
Cerebral palsy and epilepsy. Because
Well,
of
no,
this?
cerebral palsy that's not, that's a condition that is I'm not sure that's acquired by physical damage, but it
Not
could
either.
be.
I'm not gonna pretend to know exactly what the damages are, because we've always been here post plea. That was all taken care of at the time, and we've just been simply trying to get supervised visitation.
Okay, she's.
You have a pre-sentence report.
I do, Your Honor.
This is the same on each case.
It is slightly different for each, but
So all of the seriousness is highlighted with the last statement here in this police court version. In the post-sentence investigation that the court ordered, that Dr. Mitchell stated that the child would have probably died if medical care had been delayed another 24 hours, which is what would have been done had not somebody forced the defendants into getting treatment, because y'all were planning on going 2 days later. So that would have been catastrophic, obviously. Now, we had another child die in this family, right?
Yes, sir.
In 2018, under your supervision. What happened on that,
It was since,
sir?
I had laid her down for a nap.
Sudden infant.
Yes, sir.
And again, on this incident, you stumbled into the wall with the child? Is that what happened?
Yes, sir. I had tripped over a little gate that we had while I was carrying her to bed. And I don't believe that had actually hit her, because I caught my shoulder, I felt it on my arm. And she didn't hardly even whine, so I just brought her and I laid her down.
Right. What's probation's update on all of this for the court? They've been on probation now for what, a little over a year and a half.
Your Honor, I do have some new information from our CPS attorney. She has stated that the child involved in this criminal case is still not okay from her prior injuries.
Okay. So what is the plan that you're asking for?
Well, Judge, I believe
Okay.
that the next step that was discussed the last time we were here was for some sort of supervised visitation to be ordered. Although there were some things put in place for them to accomplish first, they've done that. And so I think supervised visitation would be appropriate.
Well, the state's concerned because of the medical condition of the child. What about that?
Well, Judge, the child lives with foster parent, and they would only have supervised visitation, I'm assuming, under the supervision of the foster parent.
I don't know.
Well, I
I'd like
think
to
that
know
would-
how this would work
I
practically.
think that would be appropriate. In the family courts that's generated, how it would be done is this.
How do they do it? Really? I mean, practically, how is it done?
They would typically assess a certain amount of hours per week that they will have access. It would be up to the foster parent and these parents to get together and determine when those hours would be.
Yeah, but I wouldn't want the child left alone with these two at all.
It would be supervised visitation with the foster parent. The foster parent would be the supervisor. That's
So
who.
the
currently
foster
has the
parent's got
child.
to know about this, and it's gonna have to be part of the plan. And they'd have to know that visual contact at all times would have to be done, because I don't trust none of these circumstances. I'm not convinced that they're trustworthy. They've got to earn it.
Well, I mean, Judge, we've been here a few times, and there's always things put in place for them to do before that would happen, and they.
Yeah, but when we're talking about a little child, I don't care how long, if it takes 1,000 years,
Sure.
that's not, what they want's not important. It's what the child's needs are in this case.
Should we reset it?
They pleaded guilty to injury to a child. So we're gonna protect the child, and I'm not but I say, what the proposal is like supervised visits, but how would that work? I don't want the child alone with
Their
these
rights
kids.
have been terminated already from all of their children. CPS is terminated.
Is that right?
Yes,
everybody?
that's true.
No.
That's true. They voluntarily relinquished their rights as part of the family case. So the court order of no contact prevents the foster parents from allowing them to see them, even if they wanted to.
I see.
So if the court gave them supervised visitation with the foster parents are the legal guardians, and they could deny visitation if they chose to. They're the legal guardians, and they don't have they don't have any legal right to require visitation. But right now they can't even ask the foster parents, and the foster parents could not let them see them based on the criminal court orders. So if the court just allowed supervised visitation with them, it'd be up to the foster parents to allow that or not. But right now they can't allow that.
So what would my order make a difference?
Right now you have an
If-
order, it's no contact. There's a no contact order right now. I think what would be appropriate is that the no contact order would be lifted.
And then
only
what does
under
that do?
supervised conditions.
But I thought you said the rule is they can't have contact with.
It's the court,
Under this court's,
this court's rule. No contact, but I think this court can say there could be contact under the supervision of the legal guardian, and it'll be up to the legal guardian to exercise that or not.
all right. Do you have a copy of that order of,
Terminating their rights.
yes?
I do not. The family, it's in the district clerk's office. I mean, there's no dispute that they've terminated their
I'd
rights.
like to see what the order says.
Okay.
Do you have this?
We could try to get you a copy of this.
Oh, okay. Does the probation office handle? Yeah, for anything, I mean, there's an order that's been entered. I want to see what that order says, so whatever the court may do doesn't interfere with the
My understanding is
spirit of that order.
they simply gave up their guardianship rights. They're no longer legal guardians in any way. And that's the only effect that it has. It doesn't prevent them from seeing the kids or anything. They're not legal guardians.
And why was that done?
Well, as part of the CPS case, they chose to do that.
CPS has permanent managing conservatorship of the children.
I did that voluntarily, right?
Yes, sir.
They agreed with CPS to do that. It
We
was
had to
done
go-
by agreement.
we had to go through mediation to talk with them about that. We were there for 3 hours, I think it was.
They were there in 3-hour mediation. Resulted in this.
Okay, who was that? Mr. Holmes,
Mr. Holton, he was supposed to hire an attorney, Judge.
did you get an attorney hired yet?
Supposed to be Langston.
Huh?
Supposed to be Langston.
Langston was appointed judge. And we have notes from April the 2nd, must hire a his own attorney.
Yeah, but you're working somewhere, aren't you?
Yes, sir. And that gasoline,
I'm sorry, sir.
right here in Beaumont,
Okay, and how much do you make an hour?
23.
Yeah, you need to.
I need him. I'm trying to get
See,
Langston.
you're working full time, right?
Yeah, I'm working 7/12 right now.
I know that, it's so good for you. You're making 50 grand in a year. I mean, that's a fortune to most people, but the point is that you need to hire your own lawyer, sir. You've got to pay for your mistakes and
Yes.
fix it. That's how you pay, but not the taxpayers don't pay for somebody who's making $50,000.
I understand, sir.
All right, here, get a resetting. I'm gonna give you another 3 weeks, okay, to go
that's fine.
find a lawyer.
That's
Okay,
fine.
come on up, get a resetting. Yes, sir.
Thank you, Judge.
Yes, sir. Let me ask you this. How did this termination this termination of parental rights occur? How does that occur? I mean, that was your decision to make, right?
It was part of an agreement, mediation agreement with CPS.
I know, but at the end of the day, it was their agreement.
Yes, it was their
Y'all,
agreement.
you made a free will choice.
Yes.
Okay. All right. That bothers me a little bit. That's their free will. And they said, nope. We're making a decision, not to be parents of the child, essentially.
Essentially.
What are they doing there? Why do they care now?
Well, Judge, they always cared. CPS was requesting removal.
It's their
for the
choice.
Guardian.
But at the end of the day, they didn't fight.
Well, they did fight. They mediated it out. And
They didn't fight. They made a decision how to proceed, and they elected to make a conscious decision that was voluntary to distance themselves from the parent, from the child. I think they've made a choice. And I think on all of this, that was their choice. And what I'm going to be doing is doing something that kind of changes that. Why do they want to see the child now?
I think we're talking about two different things, Judge.
No, we're not.
CPS's case was.
No, we're not.
who would
They
be the guardian.
elected to make that choice. They decided that was their free will. And it wasn't, it was an agreement that they made.
To know.
And you would know, you would understand, y'all would know what the consequences are. That you have elected to distance yourself from the child based upon all of these facts. But
I'd simply point out that CPS's involvement is not to prevent access to the child. It's who's going to make the decisions what's best to raise the child. And they made an agreement with CPS to allow someone else to make those decisions. But they'd still like to see their biological children in a visitor type role.
and the state's decision, the state's contention is no.
That's not.
Your Honor, our CPS attorney just texted me that we're bringing down the order. She said the foster parents they were placed in are not the legal guardians of the children. CPS is, and we would never allow visits. They were violating the no contact order this entire time. The parents had known them.
Wait. What was that last part again?
They were violating the no contact order. That is in their file, Your Honor. When we were here or late 2023, they had been violating the no contact order that the court had
That was
for this probation.
discussed the last time we were here. It was a birthday party. That is the reason why I believe state at that last hearing said that they needed to complete a parenting program before they would agree.
I have clause number F, as in Frank, 239683, order of termination, non-proton, filed on June 15th of 2022, which was 3 months before the defendants were placed on probation. What happened was termination of each of the parents, the defendants in this, Kayla and Raymond Spade, the court found by clear and convincing evidence that each of them failed to comply with the provisions of a court order that specifically established the actions necessary for the mother and father to obtain the return of the children who had been in the permanent or temporary managing conservatorship of the state. And it was therefore ordered that the relationship was terminated. It also states that the court found that appointment of a parent or parents in the managing conservatorship would not be in the best interest of the children and would impair their physical health or emotional development. Thus, the state Department of Family and Protective Services was appointed permanent managing conservator.
That's since changed, Judge. We do have the new managing conservatorship papers in case folks want to see those.
Judge Shelton signed this. Did you see that? You have probably smelled it.
Judge, I'm fully aware of that. That's been discussed before.
All right, here. All right. Anything else?
No, Your Honor.
Y'all are requesting that this be denied.
Correct. Judge.
Yes.
Anything else?
I'm sorry, I didn't hear what they just said.
They said that's correct. They're asking that your request is denied.
Okay, well, I would just like for the record, I was gonna put a few things on the record.
Go ahead.
For memory purposes mainly, we've been here on this issue numerous times. Primarily at our last hearing, a plan was put in place for both of these defendants to accomplish certain things so they could have access to their child. It appears to me that that goalpost has been moved. They've done that. They've done what was requested of them by the court and probation, and nothing's changed since the last time we're here. So I would like to ask the court if there is a new task that they can complete, or if what they've done in the past was in vain.
The goalpost was not changed. It's the court's determination. I'll always listen, but don't accuse the court of changing the rules and deceiving you or misleading them. That would be highly inappropriate, sir. There's strong feelings in this case by the parties, both parties, but the best interests of the child are always going to be foremost with this court. And that's the rule of law, is the best interests of the child. And the state, who is the conservator, they have flatly said they don't want your request to be granted.
I understand that now.
All right, well, that was not brought before the court last time. So don't say that goalposts are changed. That's not right to me.
I'm not saying that the court said they goalposts, but they did change because they've done what they were asked to do. They did what they're asked to do.
The state of Texas, who is in control of the children, are requesting that this not be granted. And I'm going to heed. They are the de facto parents now.
Well, Judge, there is a foster parent that is now got managing conservatorship since this year. We do have that. So for us to say that we are in charge of just.
Well, I thought that's what
That terminated and gave it to us, but in 2024, that's why I told you earlier that there is a foster parent that.
Who is it from the state that says, who is it that you were saying is denying this request?
So Michelle Brister is our CPS attorney. She has let me know that CPS will not allow these parents to ever have visitation of their children.
Judge, I think that's a battle for the CPS court. They have an attorney on that matter. They've dealt with CPS in that matter. CPS is not here, and this is the criminal court's case.
All right. I'm going to defer to the CPS. They're going to be closer to this than this court is. I mean, I can appreciate your request on their behalf, but these are the officials who are in charge under this set of circumstances over those children. And at this time, they don't believe it's in the best interests. And I'm going to follow that advice. Anything else? That is all. Thank you.
For CPS to come in and say, we never will allow visitation with these parents. Never. They don't want them to ever see these little ones again. So in my thought, there's got to be more than just he was carrying her and hit a wall, tripped and hit a wall. I mean, if you look at this man, did he land on her head? I mean, this man probably weighs 350 or more. And how could he not think that this little one was injured in that? And the fact that they let it go. They didn't call the doctor. They didn't take her to the ER. Nothing. So for CPS to say, we never want these parents to see them again, it's got to be pretty severe. And there's got to be more than just this. There's got to be some serious neglect, or they found some more injuries than just, I hit a wall. I tripped and hit a wall. I don't believe that. And maybe nobody else does either, and that's one of the reasons. They won't come clean. They won't take responsibility for other injuries, for other neglect, or for this one either, because she just hit a wall. I just don't believe that. Anyway, thank you guys so much for watching, and I'll see you next time.